This podcast is brought to you by the School of Advanced Study, University of London.
Okay, good evening everyone, and thank you for joining this, the last seminar of the RLI's seminar series this year on European Asylum Law and Policy. I'm very pleased to introduce Lilian Tsourdi. She is currently finalising her doctoral project on the administrative governance of EU asylum policy, supervised at the Universit Libre, Brussels. She is also a researcher at the Université Catholique du Libre and a visiting researcher at the Law Faculty of the European University Institute. In addition, she's a member of the Odysseus Academic Network Coordination Team, and she regularly consults for EU institutions, international and non-governmental organisations, and she has authored a number of articles and book contributions in the field of refugee and asylum law. Today, Lilian's going to be assessing the role and contribution of the European Asylum Support Office, a relatively new European agency in European asylum policy. She'll be speaking for around 30 to 40 minutes, after which we'll have space for comments and discussion. I'd like to point out that the seminar today is being filmed and will be podcast, just to draw your attention to that. Without further ado, I'll hand over to Lilian.
Thank you very much, Sarah. Thank you for the kind invitation and for all the activities that the RLI is doing for young researchers and for giving me a forum to present ongoing research. Actually, although EASO is a relatively young agency, it's already undergoing some changes. Just today, the Commission at around 2 o'clock released its proposal for a new regulation for the agency, together with a new regulation for Dublin. So the first document is 75 pages, the second 115. So you will excuse me if I don't know every technical detail of the documents. You know that we lawyers are also pedantic, but I have done my best to update this talk with the latest and to discuss also about the new envisaged mandate for the agency. So I would like to start by setting the scene a bit, because EASO and the creation of an agency in an EU policy is not something that is unique. It is unique, if you will, for the asylum policy compared with other regional programs of this type, with other regional cooperation. There is no such mechanism, for example, in the African Union or within the Latin American countries, but it is not unique for the EU settings. So agencies are a normal way, and there is the process which is called agencyfication. So in different areas of the EU construction, there are more and more agencies. So what are these agencies? They are independent bodies, so they are different than the Commission, and they are given some tasks. Others have decision-making authority. Some have even authority which is akin to legislation for some types of acts that then the Commission would rubber stamp, if you will. So there are differences between agencies, but the reason why they have been created is that there is somewhat an appeal to say that we can separate a bit the technical from the political, so that we would have centers of expertise, for example, in the medical industry or in other areas, in the environment, where we would have an expert opinion and which would be safeguarded a bit from the very intense political environment that legislation is happening in the EU. However, things do not always work like that in practice, and we will see it later when we are talking about the governance of the agency, but this is the main idea which led to the rise of agencies. So what happened in the EU asylum policy? This was at the beginning pursued mainly through legislative harmonization. So it was expected that the adoption of standards, minimum standards at the beginning, and common standards, enhanced standards later on around different areas such as reception conditions or asylum procedures would in itself bring about a harmonious result, so similar cases being treated alike similarly in the different member states. But it soon became apparent that things were not so easy, and so that legislative harmonization would not be enough to bring this result. And one of the ideas that came up was that of bottom-up harmonization. So what if we try to harmonize not only the law, so top-down, but also the practices of administration in order to bring this harmonious effect. And it is also, of course, linked, the emergence is linked with the lack of fair responsibility sharing. So there is an instrument that allocates responsibility. This is the Dublin regulation, but it does not allocate responsibility fairly. It allocates responsibility clearly, but not necessarily fairly. So in order also to counter some imbalances that were presented on the ground with member states facing disproportionate pressures, it was also considered that practical cooperation in the sense, as we will see, of deployment of experts could also counter some of the imbalances that were created by the responsibility allocation system. And then there was also, since the entry into force of the Treaty of Lisbon, a very strong principle included in the treaties. There was a different wording before, which was much softer, but now it becomes an overarching principle, the principle of solidarity and fair sharing of responsibility, that has far-reaching implications, I argue elsewhere in my thesis, that through this principle we could also see that it has practical consequences in the administration of the policy. So unsettling the initial responsibility allocation roles that were given by the treaties. So when should the EU level act, and in what manner, in order to bring this harmonious effect? There are also some obligations that are created for the EU institutions. So it was expected that many of these ambitions would actually be fulfilled through EASO, the European Asylum Support Office, which actually institutionalized prior efforts around practical coordination. So that were more ad hoc, that were not if you will, permanent structures. It was more networks of experts from national member states, coordinated by the Commission or by the Council, mainly exchanging information. And there were some first projects, for example, on a European asylum curriculum, which happened already prior to the existence of EASO. through GDISC, which was a cooperation actually of the heads of immigration services, and within there was the idea also that there would be common projects, and Sweden said, let's have a project about a training curriculum to train administrators on asylum matters, and through there you had the EASO asylum curriculum that sprang out, also with the collaboration of academics, the Odysseus Academic Network, and also the Commission and member states. So there were already some traces, but nothing very official and organized. It was more ad hoc. And then it was seen that all these efforts were not enough, that something more was needed, something permanent, something institutional that would have more resources and that would have this practical coordination of practical cooperation as a permanent task. And so we had the birth of EASO in 2010, and it is still this first regulation that is the one applicable, although we will see that already in some of its operational activities, if you will, the agency is already straining its legal mandate to its ends. But still the official text is the one of 2010. So whatever else we will discuss is just a proposal that has just been launched by the Commission, but where we have not heard yet even the position of the co-legislators. So the legal basis was one of practical cooperation between administrations, together with the legal basis of the creation of a common European asylum system. So these two elements together. Here, just to have some comparison, because we will see afterwards the breadth of the mandate of EASO, and then we need to see also in parallel the resources that it has at its availability. So these were almost 16 million for 2015. Already we have a big growth compared to one year to another for what is expected from 2016. But these are quite small if we compare with what another agency, which is coordinating actually the border management in the different member states, has at its disposal. And to think that now both agencies are being called to be operational on the ground. So to see a bit the disjuncture between ambition and resources already. The permanent staff for now were 86 persons in 2015, and we already see an explosion of 136 persons. This is the permanent capacity of the agency. We will speak later on. There is also the deployment of national experts. So these are not working permanently for EASO. They are working for national administrations for member states, and the member states make them available to the agency to send them to countries that face disproportionate pressure. So these are other than these 136. And so we will see the mandate. The original mandate is articulated around three main areas. And because these titles are a bit abstract, supporting practical cooperation, assisting member states subject to particular pressures and contributing to the implementation of SEAS, we will see exactly what is understood under each. But to speak a bit about the governance of the agency, so there is an executive director who has actually quite wide responsibilities, and he is appointed by the management board, but there is a new element. There is a lot of implication by the European Parliament that gets to interview the executive director, gets to give an opinion, which could be positive or negative as to their assignment. And also the Parliament can at any point call the director to ask questions. By the way, if you have questions yourselves while I speak, don't hesitate to stop me and to pose them. You don't have to wait for the allocated space. And then we have the management board. So what is the management board? Basically, we have one representative per member state. These are usually the heads of the immigration services or someone sent from the relevant ministries. We have two members from the European Commission and the UNHCR as non-voting members. So the management board has far-reaching activities, including appointing the director, but also more close to the day-to-day activities, such as, for example, endorsing the annual report on asylum, and we will see later where this comes in the working of the agency, or also endorsing the guidelines or technical documents. So in a way, one can understand this involvement as a bit of reappropriation. So what was taken from the member states, they take it back, because if we see the synthesis, it is predominantly a national synthesis of member states' representatives. So it can also be conceptualized like this. And the role of civil society, they do not participate in the management board. There is a separate entity that is not even considered as a body of the agency, which is the consultative forum, which meets formally once a year, but there are exchanges of the agency with civil society. It is not as structured as in the sense of actually commenting in a way that the agency would need their opinion before they do something. It is more, we have to understand it as information exchange, so civil society feeds into the work of the agency by providing information on what is happening on the ground, and then this is taken in the reports. Or members of civil society are commenting, for example, on the common curriculum, on the modules. So civil society is involved and is feeding in the work of the agency, but it does not have such a monitoring role over the agency. So we see there is a delicate balance between EASO and the member states, because EASO is trying to be an independent center of expertise, but then we see that its products also need the endorsement of its management board, where we have the member states heavily present. There is a delicate balance between EASO and Commission because of the growing tasks of the agency, but if we look at the amended proposal, we will see that actually the Commission does want this enhanced role for the agency, because there are more and more practical things to be done that the Commission doesn't have the resources to follow up on, but there is a sort of a delicate balance also between these two bodies. And there is also a delicate balance between national sovereignty and lack of resources. So the member states would very much like to keep their prerogatives on asylum and immigration and not have third experts and the EU being involved, well, as least as possible, but at the same time they have to deliver some guarantees, they have to run a functional system, they have to provide reception conditions, and they find themselves lacking resources. So in a way it's a love-hate relationship, because they need also the agency, they need the EU support in this area that is so close and so dear to them. So several tensions. Going now more concretely into the mandate. So the first broad area, which was supporting practical cooperation. Here we have 3 areas of activities. Around country of origin information, We have both production of own reports by the agency, but so far, due to the lack of resources, they were not as numerous. What it created was more a structure, a common methodology to help national authorities on creating COI, and it has created a portal where it is actually gathered all the COI that are available and giving them back at EU level. But it has made some own reports, and we will see that it is envisaged that we will go much further down that path. And it is also coordinating networks of administrators that are specialists on COI. This element will also be strengthened under the new mandate. Training. I talked to you about EAC, which preceded EASO, and it was then taken up by EASO. So it is training on the basis of train the trainers methodology. So a number of persons is trained through a blended learning methodology, meaning following part of the course online and then going to Malta or the agency coming to their country and they're following the course. And these persons who have followed a certain number of courses are then supposed to train their colleagues in the country of origin. So this is the train the trainer methodology. And there has been, with the new actually recast instruments, member states have more obligations to train their national authorities, and this has strengthened the role of EASO, because in order to comply with these obligations, naturally, they should also turn to EASO. And the last part of this rubric is quality. What do we mean by quality? It is actually a comparative work on certain aspects, for example, qualification and qualification for subsidiary protection in the case of indiscriminate violence. The agency gathers practices around different member states. It collects the good practices and it creates tools that then it gives out to the rest of the member states, basically. So this is the more famous aspect of the agency's work, which is to assist member states subject to particular pressures. Here we have several activities. One of them is data collection and analysis, the early preparedness system. So actually on the basis of some commonly agreed indicators, to gather from the ground statistics and other elements on what is happening in member states, in order to be able to see where there are particular pressures in the asylum and reception system, and to be able to start to launch actions to help those member states. So a kind of preventive health check system. Here so far, again, there were limited resources to fulfill this task, as in fact you need to have an overview of 28 different member states. And also at the beginning, as it was a new process, it was difficult also to agree on these indicators. So every indicator had sub-indicators. How do we count, for example, first instance application? What about an asylum seeker that has applied for the second time? So once you get to the nitty-gritty, it's even very difficult to see what will be your metrics. So this has gone a bit slow, but it is now moving ahead. So we will see what the Commission is envisaging for EASO 2, let's say, the next stage. But before that, let's go to the on-the-ground assistance, the asylum support teams. So there is the element of deployment of experts of EASO, but coordinating experts of member states who are to be deployed in member states facing particular pressures. They cannot actually take decisions, so they cannot assist in the way of making the decision instead of the national authorities. And if we look more broadly at the legal basis of the European asylum policy, it speaks about a member state being responsible for an asylum application. So with the current status of the treaties, we could not have fully centralized EU decision making. So the Commission cannot wake up tomorrow and say all EU decision making will be centralized. Instead of having a decision by Greece or by Italy, you will have a decision by EASO or the Commission, because the treaties say that it is a member state to be responsible. Yes?
I don't know if you're going to come to that later on, but I was just wondering with regards to joint processing that he also has been doing, because for me it comes very, very close to making a decision. Basically, it's just rubber stamped by the countries in which the decision is being made. So in practice, they are kind of doing it.
I will come exactly to that. So in the first, let's say, generation of deployment, if you will, and I did some field work in Greece in 2012, which was 2011, 2012, which was the first member state that actually asked EASO for the deployment of experts. Their role could be understood more akin to expert consulting. So they would go to the ministry and they would say, this is how you make a reception referral system to connect your asylum seekers with the available places. Or they would do training of judges. So they did not have yet any active role, if you will, at this phase on decision making. Now, what has happened recently, since 2015, is this new approach of hotspots, which is the new centerpiece of EU strategy on how to secure the management of the external borders. And there we have interagency cooperation, so EASO and Frontex, who are active in registration, identification and fingerprinting. And there was a new law. The hotspots have been activated in 2 countries, Greece and Italy. And at the beginning of April, for example, there has been a new law in Greece because they couldn't work in a legal vacuum. So there was a new law transposing the Recast Asylum Procedures Directive and foreseeing also provisions on the running of the hotspots, and they are conceptualized as an exceptional border procedure where they actually say, and this is national law, that EASO experts and interpreters can assist the Greek asylum service in interviews and in every other process. So I was in Greece in mid-April and I spoke to NGOs, but it was still very early. I was there from the 8th to the 17th. The law was actually issued on the 3rd of April, so they were not certain exactly about the practice that would happen, but it is clear that there is to be involvement in different stages. So the regulation so far says that the experts, the deployed experts can help with the initial analysis of cases. Interviews and every other process is arguably going further than that, so this is why I said that the current mandate is being strained, but of course to respond to realities on the ground. But there we have the issue of actually what you are raising, that we could theoretically, we don't know exactly what is happening and what is the involvement, we could end up to situations where we just have a national rubber stamping. For now, we need the national rubber stamping. There cannot be a decision fully taken by a body of the EU about an asylum claim. And of course, it is an issue of responding to the needs of member states that, due to our responsibility allocation systems, have found themselves carrying a disproportionate burden of the responsibility to process the applications. But yes, it is in the borders of legality, in the sense of what the current regulation foresees, that this enhanced role, actually reality, run further, faster than the ability of law to respond, and that's why we have the new proposal which gives an increased mandate to the agency.
Can I ask something? Where do these EASO experts come from? They're not staff members of EASO, so
they are staff members of national asylum authorities from other member states or working in the ministries. So working for OFPRA in France, or
and they go to other member states.
and they are deployed to other member states. So every member state needs, there is a pool, actually, like a roster, where every member state declares some certain profiles of persons, and then when there is a need, the management board has to agree, and the member states have to agree that they will actually deploy those experts. And what is difficult is that, of course, member states, as we know now, every member state almost feels strained in 2015. It's a different question of whether the numbers that have actually come to Europe actually justify this response, but many national authorities feel overwhelmed, so it has been difficult to find availability, because there is actually a possibility for a member state to say that I cannot make this expert that I had theoretically said that they are in the pool available, because now my own national authority needs them, and we will come back and we will talk about this. Yes.
See, I'm just curious, do you have any statistics on the countries that send the most experts? Or, I mean, I would...
There are some statistics actually about the latest, because you probably know that there is an EU-Turkey agreement, and then there was a deployment to be made about this agreement. So here I have some statistics. There was a request for 472 asylum experts. We have had 470 pledged, but 68 actually deployed. And then for interpreters, there was a request for 400. We have 85 pledged and 63 deployed. So we see a disjuncture between what is needed and what is there. And I had another interesting two-pager where the Commission actually had the latest state of play on the implementation of the Turkish-EU agreement, which I can't find, and where it even had a breakdown per member state. We can look for it later. Sorry that I don't immediately find it. So indeed, in the hotspots, there is a more operational role than what existed in the past. It is not clear for now exactly what is happening. There was more, so far, more support in the relocation process. So there it was in giving information and having a kind of pilot for registration. And these are all, of course, preliminary steps where there is no issue with the current mandate. But of course, now that we have this new law giving this far-reaching mandate to the experts, but we will see how it will be operationalized. And this is not in the normal procedure under Greek law. This is when we have this exception at the borders with the working of hotspots. We go back to the third area of the mandate, the current mandate of EASO, which is support in the implementation of SEAS. Here we have an annual report on asylum that I talked to you about before. So it is a kind of health check, EU-wide health check of asylum systems. under different areas, so detention, reception, procedures. There were some initial challenges about how to integrate information that was coming from civil society, but these have been largely actually dealt with, and the latest versions of this report are extensively referenced, and we have also input coming from civil society. But there is, of course, a delicate balance with the management board that is to adopt the report. And so far, of course, we understand that there can be gaps and weaknesses to national systems alluded there. And we have a management board that has to adopt the report. But I would say that on the versions of the reports that have been made so far, that have been made public and have been adopted, we see a certain quality. So it is not that there is a report that says everything is fine in Europe, no problem with asylum, stamp the management board. It is actually a rather truthful depiction of reality and of the gaps and weaknesses that exist at various levels. So the other actually part that comes under this mandate is the adoption of guidelines and operating manuals, but there is a very specific limitation to the mandate of the agency in this respect, that it must not purport to give actually guidelines on the adoption of individual decisions. So we see that when the member states started, they really wanted to closely frame the mandate of the agency. So we could say that these guides for now are more like soft convergence tools, but in the new mandate they have been very much strengthened, and we get to that. So it is not a detailed analysis of all 75 pages, but I did want to touch upon 3 flashpoints. So the first is the creation of a new evaluation mechanism. And here we have a much stronger role, because there is to be, first of all, an obligation for member states to give information. Now it was more a goodwill cooperation. Now there would be a clear obligation for member states to hand in this information. And it would be a monitoring and assessment exercise. So it would be clearly what is the health of your asylum system, how many beds do you have. There would be on-site visits, so it a bit resembles, for those of you who might know the Schengen evaluation system, so with possibilities for on-site visits and also a check, for example, of a sample of decisions. So taking in some of the methodology of the quality initiatives of the UNHCR. And then there would be a report. If there are problems, there would be measures to be identified, these kind of roadmaps that would be presented to the management board that would also make an opinion on this. And on the basis of this, there could be, one of the measures could be the deployment of support by the agency. So the asylum support teams. The difference being that if the member state who is under particular pressures and actually is in practice being deficient does not ask or does not accept the support, the Commission could prescribe these operational measures. So it's a bit like the new Frontex regulation with border guards. In situations of pressure, actually, as an ultimum, let's say, result, if the member state is not collaborating, these measures could be prescribed at EU level. So this is the proposal that has been put forth by the Commission. It is not yet adopted as law. The second flashpoint is that of a harmonized assessment of international protection applications, and here something much, much more far-reaching than the current COI. There would be a kind of common analysis, it is stated, for certain nationalities, and the EASO, it is stated, would coordinate efforts on this common analysis that would be endorsed through the management board. But after that, the member states would need to be required to take the analysis into account. For example, if there is an analysis about Afghan nationals, they would then need to take into account what has been agreed through the agency about the treatment of applications of Afghan nationals. And they would even need to submit on a monthly basis information on how they treated the applications of the relevant group. So quite far-reaching, trying to frame to harmonize standards, a much more radical way in bringing alike the same cases should be treated alike, which could go up, it could go down, depending on, in terms of when we are comparing our standards with international law, meaning it would depend on what is the common position that is agreed and what means there would be to challenge this common position, for example. And then there is also an enhanced role in emergency situation. Here again, it would not be a head steady support on a permanent basis. Again, we have this conceptualization of responding to an emergency. And here we have the deployment of two kinds of teams. These are first the asylum support teams. As I mentioned to you, this was the original function, this more akin to consulting. They would assist with case handling and reception related support, but nothing is mentioned about centralized EU decision making. And also interestingly, it would be for EASO to finance or co-finance these activities from its budget, so which is something new. But there would be also another type of teams, which would be the migration management support teams, which would come into play where we have, for example, the operation of hotspots that would work together with the teams of Frontex. And here we have the proposed regulation talking about screening, including identification, registration of applications, and where requested the examination of such applications. Question mark, that's my question mark. What do we mean, given our current legal basis? Yes?
Are EASO financing that as well?
What?
The migration management support, would EASO be financing that as well?
This, it was not, it was, the financing was under the deployment of the asylum support teams, actually.
Okay.
But I would also, as I said, this I saw from 2 to 5 until I came. I hope I'm not making a mistake, but this article with financing, I saw it under the deployment of asylum support teams. I hope I didn't miss a little provision under the migration management support teams. Yes?
Yeah, I just wanted to make a short comment, going from asylum support teams to migration management support teams, which sounds a lot like the Frontex, which is border management.
They would be working together with Frontex, actually. So in the hotspot approach, we have interagency collaboration. So there it is the situation of a mass influx of third country nationals at the borders, where also the member state clearly needs support also in the pre-stages of actually identifying and registering. And so in a way, this mixed migration management support teams, I think that the title is such because I think that they involve also Frontex, so that they would be a whole. It would be an umbrella covering all the interagency cooperation, but of course within that there is the question of respect for the right to asylum, for the human rights of individuals. So here it is to show this, this umbrella function of all agencies. But yes, there is this question mark. How can we talk about where requested the examination of such applications? I still think that of course it would mean that formally there would be some kind of rubber stamping, but we are getting much, much further even explicitly. And here is what I mentioned to you. So there is, in these situations, there is the possibility for the Commission to adopt the operational measures if a member state, as a say, a last resort. So if the member state does not cooperate, or even if it does cooperate but it hasn't managed on the ground to bring about the desired result, then there would be this deployment of the migration management teams. It's the same ratio that has been used in the new Frontex regulation, also a proposal to say, when we say new Frontex regulation, not something that is the state of the law yet. So some overarching observation, because we see that there is a clear operationalization push. So we are moving from the area of support more to the area of monitoring and of operations. And then there is the moment of truth for the budget. So this little line I took, it was very cute. EASO put it under its 2016 budget. It said any new tasks would need to be appropriately funded and resourced for the agency to be able to perform them effectively. One would think that it goes without saying. The fact that they had to say it probably points to something. So stop piling things on us without giving us money. The Commission is proposing 363 million, but over a 4-year period, so which would be a significant increase and which looks a lot on its own, but it would be divided in 4 years. And it is proposing an incremental development, but huge, of staff, reaching to 500 permanent staff. So it is expected that also the permanent staff of EASO would be much more operational and used in deployments according to the text. So we would have 500 permanent staff plus an intervention pool like the one that we have now that would have at least 500 names in it. So these are the national experts. And it is also a more restrictive wording on when a member state cannot deploy these experts. There needs to be an exceptional situation, so they're trying to frame it as much as possible so that the deployment will take place. So these were the numbers that I told you now, that you see that with the more voluntaristic, let's say, formulations that we have now, there is a difficulty for the deployments to actually take place, even if there is this nice rhetoric that EASO would do and practical cooperation would do. Here it is the point that you are raising. So we are moving from assisted or joint processing towards maybe EU decision making gradually, and this is a kind of intermediate step, which doesn't mean EU decision making that it would be bad in itself. It might even be a good development, depends on how it is organized. These terms are neutral, so it could maybe lead to something better, it could lead to something worse, depends on how we go about it. And then there is the question, will this, as I mentioned to you at the beginning, this delicate balance between national sovereignty and resources, are then the member states ready to lose one of the last bastions of national sovereignty? We will see. And the final point is on governance. So we for sure have more responsibility, even happening on the ground, but even more envisaged. More responsibility, more accountability. It should be as that. There doesn't seem to be, because there are a lot of discussions now with Frontex about an individual complaint mechanism which doesn't exist. The more operational the agency becomes, of course, the more it will affect individuals. There is nothing like that within the regulation. There is nothing within Frontex. There is nothing within here. So there are all these questions. How are we going to have now that the agency will become more operational? How are we going to have more accountability? And if we have decision making where the national authorities just rubber stamp, before who are we going to challenge this decision and on which basis? Then you will have the decision maker to say, well, I got this, it was already like that. So it's very difficult to untangle this in practice. It happens already with Frontex and mistaken identification of nationality in Greece, where it is then very difficult to challenge this because they go to the police say, well, we got this list. So it is a difficult issue that we will need to tackle. Boosting the role of civil society and transparency is another thing. Already there are some provisions about a stronger role of the forum, and we do have a good precedent in Frontex where actually the forum of civil society in Frontex has become a bit more structured. There are less members. Now the forum, to understand it, it could be an email to all the list that EASO has that says, bring us information for our annual report. No, in Frontex it is more structured. You have 9 organizations that were selected, and they are giving opinions. They manage to go on site where operations are happening. There is in the new regulation a more enhanced role that could bring the forum to something closer to the forum of Frontex, which could be a good development. It's not an individual complaints mechanism, but it's something stronger and much more structured than we have now. The forum is also to become independent because now it is chaired by the executive director, the forum of EASO, so it would become independent and it would be chaired by one of its own members. So we do have steps towards more transparency, but of course the more the agency becomes operational, the more we will need. And indeed, we see it is now a clear push. At the beginning, we had the motto being coined by the first executive director, support is our mission. And we do see that we go maybe towards more, we will go, if this passes, towards monitoring and operations is our mission, which of course brings also a whole new light into all these delicate balances that had been achieved. So we will see what happens. Thank you very much for your attention.